All rise. The Court of Appeals Division 1 is now in session.
Good morning. Thank you. Please be seated. Thank you for your courtesy. This is the time set for oral argument on our case captioned Chris Henderson and Peter Stevenson versus Isaacman, Kaufman, and Painter. Our cause number 1CA CV140045. As counsel probably know, we've reviewed the issues and arguments in the case. We've conferenced it. Hopefully we're ready for your argument. We have some questions, I suspect, for both sides. If each of you, whoever's arguing, would identify yourself for our recording, we'd appreciate it as you start. And if counsel for appellant wishes to save time for rebuttal, as is usually the case, then just let us know what you want to reserve, and we'll try to honor that. But it'll be up to you to watch the clock and tear yourself away from our questions. Having said that, please proceed.
Good morning, Your Honor. Patricia Primo on behalf of the appellants Chris Henderson and Peter Stevenson. The case we have before you, Your Honors, involves the issue of personal jurisdiction. An issue, candidly, I have not had to look at since Professor Birch's first-year civil procedure class over at ASU.
International shoe.
International shoe, and I have distinct ringings of Penoyer v. Neff somehow still living, and I came across that in some of the case law, and there were a bit of chills going down my spine at that point in time. But what we are here on a very serious issue, Your Honors, is the issue of a California law firm providing legal advice on a California real estate transaction that results in the loss of liens on Arizona real property. The trick, if you will, in this factual pattern that's different than the cases that, quite candidly, both sides are citing in their briefs is that Mr. Henderson had lived in Tennessee at the time. Mr. Stevenson had lived in Chicago at the time. The law firm is in California. So why am I bringing this lawsuit in Arizona? And the trial court judge was very adamant about why, in fact, is this case being brought in Arizona. And the issue, from our perspective, just from a common sense perspective, is as a direct result of Mr. Henderson and Mr. Stevenson relying on the legal advice or omission of the IKP law firm, they lost their lien rights in Arizona. They were forced to file a lawsuit against the lenders in Arizona. The lawsuit included a claim against the title company in Arizona.
So your argument boils down to that conduct of a California law firm towards clients, non-Arizona clients, created an effect in Arizona, meaning the loss of their lien rights and therefore the underlying lawsuit in Arizona.
Absolutely, Your Honor.
Let me ask a question about this, and one deals with the burden of proof. And when a defendant files a motion to dismiss for lack of jurisdiction, if I recall, the plaintiff then has to come forward with facts to show, or some evidence, to show, make a prima facie case of personal jurisdiction. Is that correct?
That is correct, Your Honor.
And in this case, your clients filed a response, and I think there were some emails attached to it and some deposition testimony. But can you point to anywhere in that response where there were any affidavits or vermins or deposition, sworn testimony that your clients relied on the advice or a failure to advise by the law firm as to the subordination?
And, Your Honor, there are several places. One, although when faced with a motion to dismiss for personal jurisdiction, the burden then shifts to us, it also is equally true that the factual allegations of the complaint are still taken as true.
What case says that? What case says on a motion to dismiss? I mean, I just don't remember it, but that on a motion to dismiss, the factual allegations of the complaint are deemed to be true on a motion to dismiss for lack of personal jurisdiction.
Yeah, we obviously understand that's the case on the ordinary motion to dismiss.
Right.
But
Yes.
I think we're asking about for one like this, for lack of personal jurisdiction.
Your Honors, the cases that we have cited reference that when there's any doubt that that any doubt regarding that will go to the plaintiff's persuasion, and some of the cases that we've cited in our brief, Your Honors, and let me just find them for you. The case that we cited was Planning Group, which states when reviewing a trial court's dismissal for lack of personal jurisdiction, the appellate courts view the facts in light most favorable to the plaintiffs, particularly when there hasn't been an evidentiary hearing. And that's part of the difficulty that we have, is that we also asked for an evidentiary hearing. We weren't given it, so there could have been more evidence presented.
But there's a case that actually says that if there is no that on a motion to dismiss for lack of personal jurisdiction, we will assume all the facts in the complaint, well, all the well-pleaded facts in the complaint are true.
Your Honors, I don't think I have a case that specifically says that. The case law that I was referring to, and I apologize if I misspoke, was that that the Court of Appeals looks at it de novo, that any doubts are resolved in favor of the plaintiffs.
Akin to summary judgment, we view the facts in a light most favorable to the opponent of the motion.
And Your Honors, if I can, addressing the response that we have attached. Again, there was never a challenge at the trial court level that the emails were somehow not admissible or sufficient, that they weren't sworn statements. The concern at the trial court level was, wait a minute, these emails show several different transactions. And to give you a little bit of factual background, undisputed, I believe opposing counsel can clarify if I'm wrong, but undisputed that Mr. Kaufman represented my clients in 2005 when they first sold the Spur Cross parcel.
In fact, it was later that they did not represent when the issue of that ultimately resulted in their loss of the property occurred, correct?
Your Honor, that's what we've alleged in the complaint, that that IKP did represent the clients during that time frame as well.
Secondary.
The secondary, because we have 2005, they sell the property, they own it free and clear, they get a 1-year carryback. Everyone's happy with that transaction. Mr. Kaufman is the attorney for that transaction. A year later, the 1-year balloon comes up, and my clients get the opportunity to do an additional 1-year carryback for a new buyer. And what we attached as our emails significantly was an email from Mr. Klenner, the real estate agent, to both my clients and to Mr. Kaufman, saying, by the way, just one more document here.
Right, but is there anything, that's fine, but is there any, I don't remember seeing anything in the email that would indicate that would reflect that your clients looked to Mr. Kaufman for advice on whether to sign the subordination agreement?
Your Honor, the opposing counsel actually attached some transcripts in their response, or their reply to the motion to dismiss, or their response, where they were kind of pointing the finger at Frank Klenner, the real estate agent, saying my clients really weren't looking to them. And my client's testimony actually was, well, they were looking to both of them. They were looking to both of them. And
Sorry, they were looking, your clients were looking to both the real estate agent and Kaufman.
right.
And is that somewhere in the record?
And where that's going to be in the record, Your Honor, would be in the motion to dismiss. The opposing side attached pleadings or attached transcripts regarding, and I apologize, I don't have a copy of their motion to dismiss with me, but I believe that they were pointing the finger specifically at Frank Klenner, and my clients were saying they were communicating with both. They were, that they were looking to both Kaufman as well as Klenner to protect their interests. And Your Honor, to the extent that there's any factual issues that are missing, it goes to our backup argument, which was we had requested that there be an evidentiary hearing. We said, this is a serious case here. We don't even have discovery. We don't even have IKP's file. We don't have any documents.
Depositions, and there were depositions.
The depositions were in the companion lawsuit, which is part of our damages, part of the causing an event to occur in Arizona. That's where those deposition transcripts come from.
Does it matter, changing from sort of evidentiary issues for a moment at least, does it matter whether IKP is deemed to have practiced law in Arizona?
Your Honor, from my perspective, the only issue regarding whether they practice law is whether they caused an event to occur in Arizona, because in looking at the ethical rules, there is this exception, I believe it's in ER 5.5, it's not in the briefs, but basically says that, if it's on a temporary limited basis and if it's within your practice area, then it's okay for you to help an existing client in another state, which would still mean that Arizona would have an interest in ensuring that legal advice was correct. Alternatively, because we don't have discovery, we have no factual record as to whether or not Mr. Kaufman would fall within that exception. It could also be the unauthorized practice of law, but
does the jurisdiction question, is it important at all to the jurisdiction question whether he was deemed to have practiced in Arizona or not?
The importance that I see, Your Honor, is simply from a public policy standpoint. The trial court asked the rhetorical question, why does Arizona care about this case? Arizona should care about legal advice authorized or under a limited exception under the ethical rules, that advice being provided on an Arizona real estate transaction that subsequently results in an Arizona lawsuit is accurate legal advice. From a jurisdictional perspective, though, whether it fits within ER 5.5 or it was the unauthorized practice of law, I don't think it affects the jurisdictional analysis there.
Counsel, in regard to what you said earlier, fair to say that Klenner sending communication to Mr. Henderson and Mr. Kaufman at their homes, that doesn't implicate minimum contacts having been made with Kaufman with the state of Arizona, right?
Your Honor, the minimum contacts is the ongoing representation. And opposing counsel says, wait a minute, but the malpractice occurred with the subordination agreement. And we're asking the court to look at this as an ongoing representation. There's a reason why, after a successful real estate transaction closed in 2005, why Mr. Kaufman is being approached again in 2006, and why he comes in to try and do loan modifications and different agreements in 2007, because you've got this continuous stream of activity regarding the same real estate property for both Mr. Henderson and Mr. Stevenson. So,
with a continuous stream, how come we've got such a dearth of information regarding contacts between Kaufman and the state of Arizona?
Your Honor, because the difficulty that we have is that the actual malpractice that occurred is an omission. But it's an omission. It's a failure to respond. Had there been an email that said, whatever you do, don't sign that subordination agreement, you're about to subordinate to $1.2 million each of you on two separate properties.
But is it the malpractice you're trying to address, or the contacts with the state that grant personal jurisdiction here? Because that can be any contact, good or bad, right?
Right, absolutely, Your Honor. And that's why the case law that we cited, and especially the Foley case and the Libertor case, That's where lawyers were out of state, their clients were out of state, but the actual harm occurred in a different state. And that's why we're saying that Mr. Kaufman's failure to advise regarding the subordination agreement, his failure to review the closing documents, the HUD-1 settlement statement, all of these things that any reasonable lawyer would otherwise review as part of a real estate transaction, that would have alerted my clients to the fact that, not just the subordination agreement, but that more than the purchase price was being borrowed, that there was no spousal signatures on the notes, making them essentially, forget the lien interests, uncollectible as a practical matter. All of those things together are omissions, and that's why we have to look at Mr. Kaufman's contact with the state from the perspective of 2005, failing to act in 2006, acting again in 2007 to try and fix the problem that happened in 2006. And that's why we attached all of those various emails to show that there was an ongoing attorney-client relationship. It was involving Arizona, and it resulted in my clients, losing lien rights in Arizona, having to file a lawsuit here in Arizona to minimize their damages before they could file the lawsuit against the attorney. If I may, Your Honors, it's very complicated. I'm sure you have questions for opposing counsel, and you will have a zillion more for me for my final 5 minutes, but I will turn it over at this time.
Okay, thank you very much.
May it please the Court. Good morning, Your Honor. My name is Cobra Plucker. I'm the attorney for Appellee IKP, and with me is my partner, Don Petrie. And I want to take a moment to refocus the analysis here. It doesn't matter if plaintiffs were involved in an Arizona transaction, and it doesn't matter if plaintiffs felt the effect of the alleged malpractice in Arizona. Under the due process analysis adopted by the Arizona courts, including our Supreme Court in Williams v. Lakeview, none of those things confer jurisdiction over IKP. The only contacts that matter here are IKP's purposeful direction of its activities into Arizona.
Well, what does purposeful direction mean if you're giving advice to clients on an Arizona transaction? Isn't that directed?
Well, and it depends. It depends, Your Honor, on where that client is. And there is not.
You're saying the standard is that the client has to be standing in Arizona when they give them the advice in order to implicate personal jurisdiction in Arizona?
Well, I think that is one issue when you're evaluating the contacts of the plaintiff of the defendants, Your Honor, which you have to do. There's not one case that's been cited by plaintiffs where it suggests that simply providing advice to an out-of-state client on Arizona law is sufficient to confer jurisdiction. There's not one of those cases.
On Arizona law in the abstract, or on a specific transaction involving real property here?
On either. And the reason for that, I think what plaintiffs are trying to do is to focus on the effect of the alleged representation. And that issue was clearly dealt with in Williams, Your Honor. One of the arguments that were being made by the dissent in that case is that we should look to the effect of the alleged harm. And in fact, the dissent cites the same restatement that plaintiffs cite in their reply brief. And the majority in the Williams case said, no, you can't look at the effect of the transaction. What plaintiff feels is irrelevant. It's about defendants' contact with the forum state. And in this case, Your Honor, the allegation is that my client didn't do anything, that he sat in his office in California and didn't provide advice on Arizona law to plaintiffs.
Let me raise a hypothetical on that. Let's assume that you're an attorney in just over the border in California, and you get approached by a local resident in California who's been injured in a car accident in Arizona and wants to sue the city, let's assume it's the city, a public agency, for negligence relating to the car accident. And they're going to sue them in Arizona. And so you've got a California attorney, you've got a California client who's going to have to sue in Arizona, and you fail to advise the client that they have to file a notice of claim. So they don't file a notice of claim. The suit is later brought, and the suit is dismissed for failure to file a notice of claim. You're saying that client, if they then move, if they wanted to sue you in Arizona, couldn't sue you in Arizona?
If that was the only contact, Your Honor, the answer is no. And I think the case, there's a couple cases that I think this court should focus on. I think the case that Your Honor is talking about is the Liberator case that's cited by the plaintiffs. And that case is a little bit different. In that case, it wasn't just the fact that advice was being provided about New York law. In that case, what happened was the out-of-state attorney pursued litigation actively for 3 years in the forum state. He sent discovery requests, he sent demands, and one of the important distinguishing facts is that he also attempted to engage in a fee-sharing agreement with co-counsel. So he was actively trying to enter into the vortex of litigation. Now, if you compare that to the Shearson case that I cite, that's the Texas Court of Appeals case. And in that case, you had a California attorney who was hired by a New York resident to register securities in Texas. The California attorneys register those securities. That transaction finished. And after that transaction finished, that New York client ended up overselling the securities in Texas, realizes he's got a problem, comes back to the Californian attorneys and says, I've got a problem, help me fix it. There was an easy fix, Your Honors, but the California attorneys, they missed it. They absolutely blew Texas law and failed to provide advice to the New York client on how to fix it. So the New York client ends up having to deregister all of his securities, ends up allegedly being harmed in Texas because of that, and tries to sue in the Texas court. And the Texas Court of Appeals looked at the jurisdiction issue. And one of the issues they looked at is it enough that the California attorneys failed to provide advice on Texas law, or even advised this New York client on Texas law? And they said, no, that's not purposefully availing themselves of the forum state. Simply providing advice is not purposefully availing themselves of the forum state.
Even if it causes effects, economic or otherwise, in the forum state.
Well, and the court in Shearson said the effect was felt in New York, where the plaintiff lived, where he had his financial interests in. And that's one of the arguments that we raise in our brief. The effect here is where plaintiffs live. We know for a fact they don't live in Arizona. There's a dispute over whether it's California, Illinois, or Tennessee, but what we know, what's undisputed, is that plaintiffs don't live here. And so if there's less money in their pocket, it's going to be where they live.
So the fact that they lost property rights under their allegations here in Arizona, you would suggest we disregard that?
Yes, Your Honor, because that's an effect felt by the plaintiffs. It's not a contact that defendants have with the state.
How about the fact that they had to come in here, or at least they felt they had, and try to litigate?
Well, again, that's an effect felt by the plaintiff, not a contact by IKP. Plaintiff's decision to litigate, and to the extent they're arguing that they have to litigate this particular case in Arizona, we've never had any explanation as to why they couldn't file this case in California.
No, you're talking about you're talking about this case,
right?
Before us,
right?
I think we're talking about the underlying cases.
Sure, and if it's even if they had to pursue a Arizona action in order to get recompense, that's still an effect felt by plaintiff. That's not a contact by IKP.
So if you're a California attorney representing a California client on an Arizona tax matter, he files taxes in Arizona, and the Department of Revenue later brings an action against them in Arizona, you're saying, too bad, you have to sue me in California.
Well, that's right, Your Honor, and I think that goes back to Williams v. Lakeview and the importance of the contact that defendants have with the forum state. Now, I want to make another point about Shearson that I think is very important. One of the things that we talk about in our brief is the importance of the nexus requirement, because what plaintiffs are, there's absolutely no contacts with respect to the second sale, because the allegation here is that my client didn't, it was an omission, as opposing counsel mentioned. He didn't do anything. He didn't provide any advice on Arizona law. In Shearson, you had the exact same situation. And because there's no advice, because there's no contacts on the second sale, they're trying to bootstrap contacts from what's called the first sale in the brief, this 2005 transaction, and contacts after the malpractice occurred, after the injury occurred. And Shearson dealt with that issue too, because the plaintiff in that case tried to do the same thing. That plaintiff said, well, look, we've got contacts related to the registration of securities, and this malpractice involves the securities, so that means that we've got sufficient contacts. I can bootstrap the prior work done, even though there was no problem with it, into my allegation of malpractice for failing to provide advice on Texas law. And the Texas Court of Appeals would have none of it. They said, because of the nexus requirement, because there has to be, as our own cases say in Williams, a causal nexus between the alleged harm and defendant's contacts, you can't bootstrap conduct that has nothing to do with the alleged malpractice.
When you were making that argument, you said that's because this deals with an omission. Do you concede that there was factually that there was a failure to advise the clients on the subordination agreement and they relied on it?
No, Your Honor. I'm not suggesting that at all. In fact, in our briefing, I think we make pretty clear that our position is that IKP wasn't representing the plaintiffs in this case. And we cite to several paragraphs in the record, deposition testimony, where the plaintiffs themselves say, well, they really didn't rely on Mr. Kaufman.
That seemed to me to be relating to something else other than the subordination agreement. It seemed to me that they weren't relying on Kaufman for something. It was dealing with not the subordination agreement. I didn't see anything in the record that said, where the plaintiff said, we relied on Kaufman and he did not advise us on the subordination agreement.
Well, and I don't think, frankly, I don't think that's going to be found in the record, because what they are talking about when they're talking about not relying on Kaufman is the second sale. Because remember, plaintiffs didn't have an interest in the property at this point. The only thing that they were doing for the second sale is signing a subordination agreement and entering into loan documents. And the references in the brief that I cite to suggest that what plaintiffs were trying to do was go at it on their own. They were trying to work with Klenner by themselves in order to execute new loan agreements and a subordination agreement. And what their testimony is that Brian was copied just as a matter of, quote, just it was a CC on an email. We used him less in the second transaction. I was dealing more directly with Frank Klenner on this one, and Brian was not as involved in this one. And they didn't.
Not as involved in this one?
Yes, Your Honor. But
not doesn't say not involved, but not as involved. That seems to me to at least raise a disputed fact. Wouldn't you think that should have gone to an evidentiary hearing that they requested?
Well, I don't, for a couple of reasons. First is, if you continue taking a look at the citations we provide in our briefing, it's clear that what happened with the subordination agreement is that they received it from, or Klenner sends an email. Plaintiffs are in a hurry. They don't even wait for a response to Mr. Kaufman. They take it, they sign it, and they FedEx it back to Klenner. They don't even wait for a response from my client. And in any event, even let's say my client decides that he's going to provide them with advice. Where would that advice go? My client's sitting in an office in California. If he was going to devise advice, it'd be devised in California. And then when he was going to send it, he'd pick up the phone or type an email and send it not to Arizona. He'd send it to California or Illinois or Tennessee or wherever the plaintiffs lived, but it wouldn't be Arizona.
But let's assume, hypothetically, that we disagreed with you. and we're saying, gee, these contacts are sufficient. Why not, given the state of facts that we have based on the complaint, the motion to dismiss, the response, the reply, as to Kaufman wasn't as involved in this, why shouldn't the plaintiffs then get an evidentiary hearing?
Well, two reasons. As the fact that they're the plaintiffs and supposedly had engaged Kaufman to do this work, they're the ones who are going to be in possession of these documents. They'd already done discovery, substantial discovery in their case against Klenner. So, and third, they never articulated to the trial court what they're looking for. And they had plenty of opportunities. The reason why they couldn't
what they're looking for in regard to
any additional discovery that they think is necessary for a hearing. In fact, at oral argument, there was a mention by the trial court about their request for an evidentiary hearing and to do discovery, and there wasn't really any additional information that was provided by plaintiffs. So looking at the state of the record, the trial court made the right call. He didn't abuse his discretion. He exercised his discretion just as a trial court should. He looked at their request. He looked at the alleged facts, which are that the allegations are that my client didn't do anything and didn't send any information to the plaintiffs. And he took a look to see, he gave them the opportunity to tell the court what kind of information they were looking for and expected to obtain in discovery. And they couldn't provide one answer to the trial court, not one.
Is there a case that says, I know under Rule 56F, we have that idea that if you're going to ask for more time to take discovery and to respond to the motion, that you have to come up with specific, what specifically you're looking for and think you'll find. Do you have a case that says when you ask for an oral argument, an evidentiary hearing on a motion to dismiss, that you have to show the court what you're going to find in that evidentiary hearing?
Well, I don't have that case in my pocket, Your Honor, but I would suggest that it's at the discretion of the court, that the trial court has the ability to look at all the facts that are alleged in the dispute, to take a look at the facts that are alleged in the plaintiff's response, and also, after giving them the opportunity to tell the court what kind of information they expect to obtain, to make a decision about whether it's necessary to burden the court with additional discovery in a hearing.
And what kind of information are you going to obtain from evidence, from discovery, right?
He didn't have to, because what he asked is, so you guys, he essentially said, and I don't have it verbatim, Your Honor, but essentially what he says is, so you guys want to go to California and take discovery. And the individual who was arguing before the judge said, I really don't know. I don't have any information about this. So he was completely unable to provide the trial court with any information about what the supposed discovery was going to be.
In response to the motion to dismiss, can the plaintiffs rely on the allegations of the complaint to help show why there's personal jurisdiction? Or
well,
need to affirmatively come forward with affidavits or documents or testimony?
Well, I think those allegations would have to be well pleaded at the least, Your Honor. And they had opportunities, and plaintiffs are the ones that are complaining about this omission. They're the ones who are complaining about the alleged malpractice. They had the opportunity to bring this evidence before the trial court on multiple occasions, and they simply did not. But the fact remains that even if they had evidence, there's or pled reliance, it still doesn't matter. At the end of the day, IKP has never purposefully directed any of its activities into Arizona. They've all been directed from California to California, Tennessee, and Illinois. That's it. With respect to the second sale.
How did the real estate agent know to send stuff to Kaufman? The Arizona real estate agent sends emails out. It goes to IKP, right? How?
Well, I don't know why Klenner sent the email to Mr. Kaufman. I don't have that information.
To send it to Mr. Kaufman.
Well, it could have been because of the first sale, which happened a year prior. Mr. Klenner was a real estate agent on the first sale. In the second sale, he wasn't the real estate agent for plaintiffs. He was a real estate agent at that point for the new owner of the property. He wasn't plaintiff's agent at that point. So I don't know why Klenner ended up sending the email to Kaufman. But what I do know is that the first sale, as admitted by plaintiffs in their briefing multiple times before the trial court and before this court, that it was a separate transaction. Looking back to Williams, there has to be a nexus between the contacts and the alleged harm, and there's no nexus between the first sale or any of the third transaction after the malpractice happened. The only thing that this court should be looking at is the second sale.
But your point, I think, is dependent on the conclusion that there was no harm to the plaintiffs in Arizona.
Well, my analysis doesn't. In my analysis, it doesn't matter where plaintiffs felt the harm. The Williams case says that the effects don't matter. The Williams case says all that matters are defendants' contacts with the state, defendants purposefully directing their activities in the state, and the nexus, the causal nexus between those contacts and the harm alleged. So the effects test that plaintiffs are trying to use now is not the right standard. Now, Your Honor, the trial court concluded that allowing this matter to go forward in Arizona court would offend traditional conceptions of fair play and substantial justice, and it was right. The Due Process Clause does not allow the court to extend its hand into another state and hail an out-of-state lawyer into this court for simply advising on Arizona law, or in this case, not providing advice. Thank you, Your Honor.
Thank you very much. Rebuttal, Ms. Primo.
Thank you, Your Honors. And I would like to start with just some references to the record. I didn't have them available initially, but that's what rebuttal is for. In our response to the motion to dismiss, Exhibit 1 was a deposition transcript of Chris Henderson. Again, that was in the context of a lawsuit against Mr. Klenner, the title company, and the borrowers who had failed to pay back the loans. And at page 62, these are questions that are being, asked by opposing counsel. At line 18, it says, so you hired people like Brian Kaufman and Frank Klenner to advise you as to how to properly complete these kinds of transactions. Answer, I hired Brian Kaufman. Frank Klenner approached me, but I trusted him. At page 63, line 9, so you hired lawyers like Brian Kaufman to protect your interest and make sure everything was done properly. I object to the form, and the witness says yes. Mr. Rose, given what you felt like your level of expertise, do you think that you would have followed whatever advice your lawyer gave you? I objected to form. The witness said yes. That is our evidence in the record that Mr. Henderson was looking to Mr. Kaufman for advice.
Now, was that in regard to the first transaction, the second transaction?
This is regard to the second transaction.
Define that transaction for us.
The second transaction is 2006. My clients are about to get paid off on their seller carryback that expired in 1 year. Now the new buyers, Vertus and Mead, are coming in as buyers and saying, hey, you know what, would you like to earn another 10% for an additional year? Why don't you carry back for one more year? And my guys say, 10%, that's not bad. We own this property free and clear. It worked for the first year. Let's do it for one more year. Then comes the subordination agreement. Oh, by the way, your $240,000 is going to be subordinated to $1.2 million. The Exhibit 2 to our response to the motion to dismiss is also Pete Stevenson's deposition at page 24. Do you believe that you would have heard either from Chris Henderson or Brian Kaufman, hey, don't sign the documents yet because we requested, X, Y, and Z, and they haven't gotten it yet? And I object, and the client says yes. So again, we've got, and the issue about, so why would Frank Klenner be communicating with Brian Kaufman. Why is he even in this? Because we are continuing the very first transaction. When I say no malpractice occurred in the first transaction, that's because everything went the right way. But the transaction is being extended an additional year by doing a second carryback. That's why Mr. Kaufman is involved here. We are not jumping the gun when we're talking about the effects being felt here in Arizona.
Before we run out of time completely, would you comment, please, on Mr. Plucker's argument, and I'm going to paraphrase poorly perhaps, but I'll do it, that the Williams case has rejected the effects significance or test?
Well, Your Honor, I think both parties agree that basically there's a three-pronged test that the court is looking at. The very first one is the minimal contacts, some sort of minimum contacts with the state of Arizona. And we're saying that those contacts can also be omissions, the analogy being a failure to file a lawsuit within a statute of limitations. The second part of it is that it arises out of or relates to the defendant's conduct. So that's part of that due process fairness notion. So I agree with opposing counsel. The very first thing you need to have are those minimum contacts. It has to be reasonable for you to foresee that you might be hailed into an Arizona court. And respectfully, Your Honors, providing legal advice on Arizona law for an Arizona real estate transaction that results in an Arizona lawsuit to minimize the damages caused by that omission is that reasonableness, that it's reasonable to be hailed into court. And then finally, basically, those are the three elements. So if there was absolutely no harm here in Arizona, we wouldn't be here in Arizona because there'd be absolutely no connection at all.
What's your response on Williams, where he says it doesn't matter that something may have happened in Arizona? You felt the effects where the plaintiffs lived.
Your Honor, I don't think that Williams goes quite that far to say you felt the effects where the plaintiff lives, because then the issue becomes, so is there one lawsuit in Tennessee and is there another lawsuit in Illinois? That's only one of the aspects, and also our facts are very different. It's not the monetary loss. It's the loss of lien rights in Arizona. It's the lawsuit that had to be filed in Arizona. And I think Williams primarily focuses on the fact that we don't even need to get to that if we first find that there's the minimum contacts with the state. Respectfully, we've got transcripts that indicate that there was reliance on Mr. Kaufman, there was an ongoing transaction, and my time is up.
Thank you very much. We appreciate both of your arguments and briefing on this. We'll take the matter under advisement. We'll have a brief recess to allow the next case to come up and get ready. Thank you very much.